Thank you, honorable members. Thank you, honorable members. You're welcome to the meeting. This is a continuation of, or it's a progress on dealing with the bill that was tabled by Parliament, by Department of Human Settlement in Parliament. And therefore today we'll try to finalize issues that were in question mark before we look at the draft list, list on, and then it's called the A draft. And then if we then agree, all of us, that is what we want, and then we'll proceed to B, which is towards the final of the of the bill. So with that, with those few words, I want to welcome honorable members and the teams and invited guests that are part of us, and the listeners that might have joined this meeting. I'm going to request that we observe a moment of silence for meditation and or prayer. Thank you very much. Can I then move for the adoption of the agenda? Honorable members.
I move, Chair.
Second.
Honorable Malaji moved and seconded by Honorable Zeki. Thank you very much. Poliswa, can we note apologies?
Good morning, Chairperson. Good morning, honorable members, and to our guests. I have two apologies for today's meeting. Mr. Heron is not able to join us, and Mercy Flwai will join us later. She's on her way to Parliament. Thank you, Chair.
Thank you very much. I'm now going to give the department or the legal service of Parliament to take us through those issues that were still on the gray areas, and then we'll then get the department to respond. And pardon my voice, I've got the flu. Legal services.
Good morning, Chairperson. Good morning to all on the platform. The A list was circulated as drafted by the State Law Advisor with the input of the department and myself. So it's just for members to go through the A list received. If Kholiso could kindly just fly to the A list, and then we can go through that. Thank you, Chairperson.
I thought before we go there, we would get the department to, you'll identify those issues that they were still needed to be ironed out, and department were requested to go and look at it. One of the issues that I know was the issue that was raised by Honorable Harold on the constitutionality of the act based on the assignment of given for members of the executive committee and the MMC. And then the other one was on the issue of the NGO issue as raised by Honorable Powell.
Yes,
So,
Sorry, my apologies, Chairperson. So the department has prepared a document just explaining the TRUs and the NPOs. They can take us through that. And then just with regards to what the Honourable Heron raised, we have addressed it in the A list. So perhaps the department can come and discuss those two issues that they have prepared, and then we can go through the A list, which deals, we've tried to address those issues in the A list. Thank you, Chairperson.
Okay, thank you very much. Department. Mr. Masemola.
Thanks, Chairperson. I am with DDG Cheney and acting DDG Rashni in the platform, but I will take it on the non-profit company, or rather, let me allow them to take us through those two. DDG Rashni.
Good morning, Chairperson, and good morning, honourable members and colleagues. Paul, do you want us to flight the input, or do you want me to speak to it?
Flight it, ma'am.
Thank you, Chair. Let me just try and get it up. Oh, there it is. Thank you. Thank you, Paul. Chairperson, on the non-profit company, the input there is that we're saying insurance companies do naturally profit from insurance that are sold to the end user. This, of course, assures the lifespan and financial sustainability of an insurance company. Home loans are also almost always offered with an insurance policy, which makes the entire housing finance product more expensive, and hence we've, as the state, always tried to introduce or looking at options of how do we ensure home loans are affordable. So government has a responsibility to ensure that ultimately the end user, and our primary focus is on low-income households, do not carry the cost of making a profit along the value chain of a home loan. Therefore, the establishment of an entity such as a non-profit company or a similar entity is in the interest of ensuring that there's affordability and access to housing finance, also including insurances. So any company or entity which is offering a financial service, Chair, it can be a trust, it can be an NPO, it can be even just a small company, any company offering a financial service must, in terms of the Financial Services Board regulations, must register as an FSP. And for that to happen, that entity has to go through the entire due diligence process, which includes whether it is feasible to establish an MPO or not. So, Chair, the fact that this is included doesn't mean that it is a finality. It still has to go to the entire process of establishing whether within the range of companies or similar entities that are available, that similar offerings are not going to be duplicated. So the FSP, the FSB, the Financial Services Board, will then make a determination on whether this is a viable entity to set up or not. Of course, the council or the NHBRC does have the option to enter into partnership with various private sector role players that are offering a similar product, and of course, looking at how this impacts on the end user in terms of costing. So, Chair, that's the input on the non-profit. Thanks, Chair.
I thought you were going to proceed on the temporary residential units.
Okay, no problem, Chair. Chair, in terms of the TRUs, the scope of the bill does not cover temporary structures. The standard of the TRUs is determined by policy and code, which standards are not similar to those of permanent structures. So what is in the policy is not the standards that we are indicating in policy is not similar to those of a permanent structure. So consumers who have challenges with the structure of a TRU have to register their complaint in terms of the codes and not the NHBRC. Chair, I think the ultimate intention about the TRUs and consumers is that we want to protect the rights of the consumer. So ultimately, we should be able to guide or ensure that the consumer has relevant information, understands what the policy or what the legislative implications are, or what their rights are in terms of receiving a TRU versus a permanent structure, noting that the standards are not similar, but that they have recourse if there is issues around the quality of those TRUs. Chair, that's the input on TRUs. Thanks, Chair.
Thank you very much. Can I then get members to talk to the issues?
Chair, it's Honourable Powell.
Yes, honourable member.
May I request that the committee be taken through the A list?
We're still coming there, honourable member. These are the issues that we have to resolve and agree, whether we agree with the presentation of the department on the issues that members have raised, and then we'll then be going to the draft A list.
Chairperson, I would like to submit, because there were a number of issues that were raised, only 2 of which have been covered in the TRU and the NPC explanations, a number of which are also not addressed in the A list. So are you wanting us to speak to the rationalization of the department or make further suggested amendments to the bill? What exactly are you asking from the committee at present?
Honorable Powell, when we're interacting with the department has been responding on the issues, and they were as we were raising issues, they were clarifying them, and then when we come on this one on the NPO, they requested that they must go back, and then we'll bring the answer and the issue of the TRU, and the issue that was which was a constitutional matter, but the parliamentary legal service says that the issue of the constitutionality of the issue of which was raised by Honorable Harold is being dealt with in terms of the A list. So I want us to agree that we were satisfied with this response, and then we go into the A list, and then we then debate if those issues, if after the interaction and after the members have raised issues and there was an agreement in terms of incorporating some of the issues, if we'll then check whether they're still there. If they are not, we'll then actually still amend the bill itself. But I wanted to give them opportunity to deal with these issues that was referred back. Honorable Butaseki.
Thank you, Chair. Indeed, Chair, issues that are being clarified, excuse me, if we want to add them on the A list, we can do that with pleasure. But on the TRUs, I think the department, in my view, has not completed that. To say any issues of concern in relation to the TRUs are not NHBRC issues, but are departmental issues. In other words, is the responsibility of the department to address those issues. That's my understanding, Chair. Thank you.
Okay. Honorable Powell, your hands is still up.
Hi, Chair, yes. So the discussion that the committee had during both presentations last week, there was concern not over the phrasing or the legalities with respect of the NPC registering as a financial services provider. It was explained to us last week that the necessary compliance measures will be enforced should the NPC be established. Rather, the concern from a number of members of the committee was on the substantive nature of the necessity of government establishing a non-profit company that will essentially compete with the private sector. Now, the rationalization that was given to us last week is precisely the same rationalization that is contained in the a presentation that's just been given to us, that essentially the idea here is that by establishing a non-profit company, the contributions of ordinary members of the public will be lowered, and therefore this NPC will be able to essentially compete with the private sector. Chair, this service offering is not within the purview of government. We have got multitudes of banks, mortgage lenders, and of insurance providers who have existing, already competitive offerings to the private sector in respect of insurance. Now, the establishment of an NPC of this nature will require all sorts of income streams and funding streams in order to staff its required staff establishment, premises, running costs. All of the operating costs that will be required will be relevant and will need to be funded in addition to the existing service offerings of the National Department. Now, when we look at the performance metrics of the National Department of Human Settlements and its various entities, we see that it achieved 41% of its targets last year. So it's battling to even achieve the very basics. And I think that it's prudent at this point that our committee deliberate on the substantive nature of Section 39, whether or not we believe that it is wise and that it is prudent and that it is even necessary for government to now, via this piece of legislation, be extending its service offerings that are in a way going to compete with the private sector. Chairperson, it is my submission to the committee that we call the Minister of Human Settlements before the committee to come and have an engagement with us on whether or not it's prudent to proceed with Section 39 included to any end whatsoever. I've gone through, Kaliswa sent me the summary of the bill that was presented at our public hearings, and there is virtually no clarity that was given in the summary documents that we provided to the public when we traversed the nation as to the nature of why this nonprofit company will be established. It certainly doesn't say anywhere in the summaries that we gave to the public across all 9 provinces that the purpose and the nature of the nonprofit company will be to offer private sector insurance that will compete with mortgage lenders and insurance providers. So I don't believe that we've had enough of a robust engagement with existing financial service sector providers, nor with mortgage lenders. And I don't believe that it's been made clear enough in the summaries of the bills that we discussed and engaged with on the ground, what Section 39 was ultimately seeking to do. I think that if we proceed as a committee, there's going to be a huge backlash from financial service providers and banks. And I think that it's going to ultimately cause quite a headache in terms of this bill. So my two submissions in summary are, one, that we request the Honourable Minister Kubayi to come and have an engagement with this committee on Section 39, and secondly, that the committee considers my request that we remove Section 39 from the bill in its entirety. Thank you, Chair.
Honorable Masuta, honorable members, Honorable Powell has made the proposal that he thinks that we should remove Section 39, or we should invite the minister to come and engage on the issue. Honorable Masuta.
Exigency, Chair.
Yes.
Are we already on the A list? Because I think we were still on the first clarifications. Because Member Powell is taking us on the A list, which
Chair,
you have not guided us, Chair.
Chair, that's why I asked that we do it all at once. Nevertheless.
Honorable Tseki, the procedure is that if there are deferred issues, because on the other engagement that we had, there were answers and there were clarification on this issue were sent back. That's why we're given the department an opportunity. They've requested to go back and they are bringing this answer. And it's upon members to say that we are not, like honorable member is saying, I'm not happy with the response. Therefore, I propose that is a proposal. And then we can then agree to move towards, with note the issues, will actually deliberate when we come to the A list or not. Honorable Masuta.
Yes, Chair. I may have missed earlier engagements around this matter. I recall that when we did discuss the TRU, there were issues around standards and ensuring that issues of safety and human habitability of those units, even though they were temporary in nature, as well as the question of what does temporary mean, given that some of them can go on as the only alternative means of abode for those that have been provided, were some of the policy issues that needed to be clarified at the time. I don't know how those issues were resolved, because the answers that are being given to simply say this is the baby of the department and not of the entity, I'm not sure whether it clarifies the policy around them, and whether, and I'm not sure whether the issue is still whether this bill should have any say on it, or is this a matter to be regulated elsewhere? So that clarity at this stage is not quite obvious to me, and it's probably because I may have missed out on some of the discussions with all these load sheddings and being cut all the time and losing touch with developments. But coming to the second issue relating to the financial sector and the interplay between this portfolio seeking to make housing more affordable and accessible through various interventions that relate to financial aspects in this regard. In this instance, the focus being insurance cover that is affordable. I would want, like I've said last night, now in private discussions, I realize that
we're
I
losing
need
you,
a
Honorable
lot of
Masuta.
education about,
We're
and in
losing
this
you,
instance,
Honorable Masuta.
yeah, it's part of this load shedding and the networking issues that it comes with. I find it difficult to participate in these meetings because from time to time, these network issues just throw a spanner, and then one loses, participation in the entire process, which is very frustrating. Am I still being audible?
Now we can hear you, Honorable Masuta. Can you repeat
Yes.
on the start on the NPO thing?
So what I'm saying is that having touched on the TRUs, the second aspect that's being discussed, and that is that of the financial aspect with regard to supporting access to housing and the role of this department. And in this instance in particular, if I understand correctly, the narrow focus being on insurance, but accepting that insurance is but one of a series of financial services that relate specifically to housing, where this department has a role to play, but playing that role in an interactive and mutually reinforcing and supportive way with other state actors, such as the regulatory institutions, is an area which is fairly murky to me, and I need a lot of education as one of the areas which I regard as intersectoral, and how this department interfaces, for example, with the economic cluster, and in particular, the financial portfolio or in particular treasury around policy matters and the legislative interfaces between what we provide in housing legislation to access to financing, affordable financial to housing on the one hand, and the role of treasury or the financial sector really not only regulating but providing from the private sector side the necessary products, be they financing, insurance, and a whole host of them. So I think that if we were to be given a more comprehensive picture, or if I was, because I tend to assume that everybody else is on board and understands how these things interplay, and because I'm a newcomer here, I'm the one that needs more education. But the kind of education that would assist me to have any meaningful contribution here is just to understand the interplay and the collaborative relationship between what this department or portfolio seeks to do within framework of the regulatory that the financial sector on the government side and the providing sector on the private side, and things in between, interface, so that we have a seamless system or framework of financial support that's affordable to those that need it, with specific focus to housing in an integrated fashion. One of the issues that I raised right at the beginning when we were dealing with this bill is the issue of cross-referencing. And I specifically said, I see little cross-referencing between this bill and other legislative frameworks that are already in place that impact on some of the policy matters that we're seeking to address in this bill. And I even asked, has there been sufficient consultation between this department and, say, the economic sector, as in especially the financial sector, both public and private? And I was given the assurance that this bill went through all of those consultations and that there is harmony and collation and collaboration and or harmonization, etc., between what this bill seeks to achieve and what the other sectors are offering or are already doing, or is contained in their policy and legislative frameworks, so that those issues are dealt with. But it would have been nice to see that in the way this bill is drafted, in the sense that where, for example, we are talking about this specific issue, specific reference is then made to the regulatory framework that govern the financial services sector to the extent that it's necessary to be mentioned in this bill. So the architecture here, my own experience of drafting, having been a drafter myself in my own right, when I ran a government legal services many moons ago, is that you don't assume that laws will talk to each other. You make laws talk to each other by being specific about it. If you know that a particular provision impacts on another provision in another sector, another sphere, say so. Don't assume that it is given. So I'm not sure to what extent that approach has been applied here. But I'll pause there, Chair, and just say that it's been a bit of a frustration on my side, and maybe it's based on ignorance and lack of understanding of the mechanics of this legislation. Thank you, Chair.
Thank you very much, Honorable Masuta. Honorable Dr. Masemola, you'll come last. Let me give it to Dr. Khumalo, and then you'll actually give an opportunity to respond and clarify some of the issues. Doctor?
Thanks, Chair. Good morning, colleagues. And thank you for the presentation or the clarity rather given. Chair, I would like to not maybe take too much time trying to repeat a little bit of what Honorable Masuta has said and what Honorable Powell has also touched on. I tend to relate to a number of their points, which I'll not necessarily go over, but would like to rather support the proposal put on the table, just so we can satisfy ourselves, Chairperson, on section 39, for example, particularly because of the impact and the consequences that it may carry or that it can carry. I think it would be a good idea for us as a committee to ensure that we have, backing and support of the relatable financial sector to section 39. Thanks, Chair. I think I'll just leave it there in the interest of not having to carry on and on as well, in repeating a little bit of what both members have told the committee already. Thanks, Chair.
Thank you very much. I don't see any other hands. Honorable Mr. Masemola, as you talk about this issue, the section 39, you have the financial institution which is providing assistance through the NHFC. Why do you want an NGO when you have the financial or the aspirant a bank that can then play the role? Why do you need that? If you can just clarify those parts, and then so that we go into other matters. Mr. Masemola.
Thanks, Chairperson and honorable members. The Honorable Masuta, indeed, there were consultations that were made, which would include banking associations of South Africa and other institutions. But maybe on issue of what is being raised by Honorable Powell, I think the issue that, Chairperson is covering it, it's whether it's desirable for government to be taking part on issues of insurance and so on, which I think that's basically what Honorable Powell is saying, and saying that currently the sector, or rather the department and entities, are not necessarily performing very well. So we're adding more, perhaps, burden on the entities to be involved in issues that should best be left for private sector. Now, this section is not saying it must happen. It says first there will be assessment, and then that of whether there is a need of having that non-profit company. If there is a need, that's when that can happen, and it will follow all the legal prescripts. So, but the fact is, there's nothing that precludes government to take any step to ensure that it protects its people. And I'll give you an example on the part of the insurance. Sasria it's a government insurance company. So it is not necessarily that it's a new, pardon me, it's not a new phenomenon where government decides after making assessment that there might be a need of having to enter into that space. So that decision is not just going to be made that, no, let's go into that space, but there will be compelling reasons at the time. So you don't want to start afresh and go to the act, try to amend it when there is a need. But you will still have this clause standing there. When that need arises, there will still be consultations around it. It will not just happen overnight. So I don't know what really causes this confusion on something that is just an enabling clause to allow government or council to say, after making assessment, there's a loophole here which government needs to ensure that it improves on the protection of the consumers. So that is the intention of this clause, nothing else. It's not going to be implementable now, but it will only be implementable when it's necessary and after consultations. Thanks, Chairperson.
Thank you, Mr. Masemola. Mr. Malemato.
No, thanks, Chair. Morning, colleagues. I think Mr. Masemola is actually assisting us. But with him was saying, let's have it that in case, which is not far from what Comrade Masuta was saying, we want to assume. In this case, he says, in case they rise a need. Now, Mr. Masemola must be educated that it is very dangerous to avail in a platform with the view that in case something might arise, and you'll find that people are working on it and decided to misuse it. And by that time, that platform is there. So it is very good that to tighten up the bill, that it must not allow such. Instead, it's you who are saying this. There are existing institutes that they're supposed to perform their duties to ensure that they protect the consumers. In this case, one will say, let's rather enforce those which are existing so that they perform their duties so that we achieve our objectives. You know, the danger of this one that we want to create is just we'll be repeating. I'm not sure if we are fast to forget. For this one to go and enter the market itself, whether it's a non-profit company or profit company, the danger is that if the company goes where, I mean, if the government enter a market which naturally is a profitable market, and it comes and say, we are here to perform this non-profitably, it causes a problem to the existing profiting companies because they are going to say, you as the company, I mean, as the government, you are behaving like a conglomerate. You want to own up everything. You want to participate in everything. Here you are here to impoverish us wealth. You don't want profit. You are here to destabilize the market, and it becomes a problem, Comrade Chair. I just wanted to let Mr. Masemola understand it from that angle and avoid to put opportunity for those who might come in future and miss this opportunity. With that, I want to agree that let's not consider it. Thank you.
Thank you. Thank you, Mr. Malemacho. Maybe Mr. Masemola and the DGG, I'm going to give you the last words. Why don't we then say that human settlement should strengthen its financial institution for them to provide the services that will make human settlement to move with speed in establishing the bank, which actually will play all the role and equally competing with the private sector and defend the interest of our people. Mr. Masemola and the DDG that are here.
Sorry, Chair, I've raised my hand, if you will allow me before they respond, just a follow-up on the last speaker.
No, yes, it's your hands and then followed by Honorable Powell and followed by Honorable Malachi.
I think the last speaker just made a powerful statement. You see, my own experience of legislative drafting, you don't want to swallow the whole elephant in your first stab at, right? There will always be outstanding issues that can be dealt with later. The question is how urgent, how strategic, how central, how critical, how unavoidable is this provision that you are including? if it's just one of those things that deal with possible eventualities, as seem to have been the motivation here, I would say, why not wait, go and do more homework, and allow the bill to deal with other more important and pressing issues that this bill has to deal with? Because part of the problem, as the lawyers here would know, and maybe you don't even have to be a lawyer to know, once you put something in legislation, you raise expectations. And if you sit back and spend 10 years and not actualize that which you have committed yourself in legislation, you are exposing yourself to those who have an interest pushing you through the courts to operationalize it. They can use instruments at common law like a mandamus, compelling you to create principle that the act has enunciated, that you give expression to that which Parliament has expressed as a wish by putting it in legislation. So remember that principle. Don't force every little thing just because it is possible to go into your first step at a legislative reform program. This legislative program is so extensive. It deals with so many issues which are fundamental. Do you have even the capacity to manage the implementation of all of these things the moment you have passed this legislation? Or you want to confine yourself to that which you have the capacity and the resources to manage at this point in time? Those are some of the questions when you decide on the parameters that your legislation wants to cover. You look at. But I'll just pause there, Chair, and leave it as a food for thought for the department whenever they draft legislation. Because once you put something in legislation, it's not a by the way issue. Legislation is not a white paper where you can express all your aspirations for the next 100 years. Legislation, once it's in place, it establishes rights which can be invoked almost immediately after it comes into operation. And that's something you must be particularly sensitive. Thank you, Chair.
Thank you, Honorable Masuta. Honorable Powell.
Thanks, Chair. Just three things. Firstly, I'd like to just clarify, Mr. Masemola, I don't think he's from the department. I think he's from the ministry. I think he's the minister's PLO, not a spokesperson from the actual department. I just want to touch on one point that that Mr. Masemola made. He compared Section 39 to SASRIA. Now, SASRIA is a totally different ballgame because it covers high-risk riot insurance that the private sector doesn't cover. So I think it's a false equivalence to compare the provisions of Section 39 to SASRIA, given that the private sector in fact doesn't cover and explicitly excludes insurance for riots, etc. And then I'd just also like to second what the Honourable Masuta has said, that it's indeed dangerous to include this provision that provides for the establishment of any given entity or vehicle in case it's needed down the line. This NPC can be established later via its own piece of legislation if necessary. And I would absolutely like to second Mr. Masuta's contribution that it ultimately extends the purview of this current bill before us far beyond its intended mandate. And then, Chair, the third thing is you made a proposal, but it wasn't particularly clear. If you could just repeat your proposal, I would appreciate that. Thanks, Chairperson.
I was saying, Honorable Powell, that the department, they have the NFHC, which is a financial institution, financial, whatever you call it. And the NFC, the NHFC, then they are in the process of establishing a bank which will compete with the market, because it's not about competing with the private sector, because the competition is allowed, that government as a buyer or as a developer or as a having that looking at the interest of the people. Why the department is not utilizing what they have, if they think they will need such things. Because when you have a bank, you can then be able, already you have established a bank which can then participate in the financial competition in terms of the market itself. So then to have the act that talks about the NPO, which majority of the time the money that you're going to need will be from this bank that you're going to establish. So that's what I was asking Mr. Masemola, and he has not actually responded on the matter. Let me give me Honorable Malachi and then Honorable Butas.
Thank you very much, Chair and honorable members. I think the most important thing that we need to agree on as a principle is that when we make laws for the benefit of our people, and mainly the benefits of those that are disadvantaged to be advantaged. Now, that is the most important thing that we focus on, because we might not be seen to want to engage an issue that has to deal with the resolving the socio-economic challenges. And we sound like we want to protect those that have been advantaged even before, or protect captains of the industries that are beneficiaries of when acts like this don't exist, issues like banks and many other areas that benefit from the exploitation of our people. Now, I felt that I must make this highlight, Chair, so that whenever we debate on this issue or other issues, we keep that in mind, and we're reminded that we are a people's-driven parliament and mainly biased to the poor of the poorest. Now, that is what must always ring in our minds every time we deal with such acts. And I feel that I must make that contribution, Chair, as we're discussing these matters. Thanks.
Thank you, Honorable Malachi. Honorable Butas.
Thank you, Chair. I just read that clause twice, and it's having a doing word that says may, meaning that it's not instructive. So based on the potential discussions there, my view was that if we could suspend it and deal with it at the end, because I know Member Powell is representing a particular class. And when that class is being contested in terms of
Objection,
its power,
Chairperson. I'd like to raise an objection.
at all times, people like her will stand up.
Point of order.
So my view is that let's suspend the
Chairperson,
debate.
point of order.
because
a point
I
of
think
order.
this act, it's
Honorable
actually
Tseki.
taking us forward.
Honorable Tseki,
Thank you,
there is a
Chair.
point of order.
Okay.
Hang on, Honorable Powell.
Chair, this is the Honorable Tseki has just cast aspersions on my character. This is a very important A-list meeting. He has suggested that I represent only the views of a certain class that is casting aspersions. I'd like you to ask him to withdraw, Chairperson. Thank you.
Honorable Tseki, can
Okay, Chair.
you withdraw?
Chair, Chair,
Yes, Honorable Malachi. Yes.
I don't think Honorable Tseki is out of order by making an analysis like that. If Honorable Powell has a different view, it's not an issue that is out of order. There's nothing out of order by saying that an honorable represent or his politics represent a certain class. I don't think there's anything out of order there, Chair.
Okay, honorable members, in terms of the rules, any casting of aspersion, you have to do it with a substantive motion. So
Yes.
that's why, yes. So that's
Okay.
why I'm saying Honorable Tseki must withdraw. If Honorable Tseki has got that, he can do it through that rule, and then it can then be debated in the House.
Okay,
Chair, if
you are
I
right.
may assist, we don't even
can we-
need to invoke the rules, Chair. I think the spirit that must prevail in committees should always be that of collegiality. We can slam each other in the House as much as we like and let the presiding officers call us to order if needs be and rule on those things. But my experience of how committees are run in Parliament is different.
Honorable Masuta, let me call you to order. Because I've made a ruling that Honorable Tseki must withdraw. Because any casting of aspersion, the rule, when we are in a committee meeting, you don't suspend any rule of Parliament. You continue to uphold those rules of Parliament in the committee. This is a mini Parliament. Honorable Masuta. So, Honorable Tseki, can you withdraw and then proceed with your input?
Let me withdraw, Chair. I will actually bring substantive motion in future. I withdraw for now. Chair, all what I'm saying, I read, like I was saying, my point is that if we still view that act in that section differently, like one have assessed it already, because I was going to support it based on how it has been written. Of course, understanding the question that Member Masuta is giving us. Thank you, Chair. So I was thinking that maybe we can move and deal with it at another time. Thank you.
Thank you very much. Doctor, I see your hand is still up.
Thanks, Chair. I raised my hand after the utterances by Honorable Tseki, but I trust that that matter is dealt with. And yeah, I think it's very important, Chair, that when we debate ideas and we debate based on the interest of the people of the country. And if we're going to start discussing each other's opinion, what we think of each other, I think it's going to derail us. Chairperson, we are discussing an issue here where I think submissions have been made by 3 honorable members that we perhaps leave this section out. And I would like us to maybe move on that front, because it would be very important for us as a committee to see eye to eye and have an understanding amongst ourselves as a committee. as Honorable Masuta says, a united front. We've got Honorable Malimecha gave a view that aligns to Honorable Powell, that aligns to Honorable Masuta, yes, myself as well, Chair. So I think we have consensus to a certain extent on this matter, and I'd like that we move based on the inputs and submissions that have been made by the committee as we are discussing this morning. Thanks, Chair.
Thank you, Honorable Doctor. Honorable Malamacha.
Oh, it's a
Is it the
legacy.
legacy? Okay, thank you. Honorable Malachi, is it the legacy hand?
Yes, Chair.
Okay. Honorable, okay. Masuta, it was the legacy hand. Okay, thank you very much. There is a view that this clause should not be included in the Act, section 30, is it 39, in the bill, my understanding is that there is no member who says this thing will not be done at the time it's been needed to be done. Can we then proceed to the draft of the new to A list?
Seconded, Chairperson.
Not so quick, Member Powell. On a lighter note, Chair.
Okay, thank you. Can we then proceed maybe just to Honorable Masuta?
It is not viewed.
We can't hear you, Honorable.
Yes. Hello,
We
Chair.
can't hear you.
Just before, I've just started with load shedding, so the network is going to be a problem again. Can you hear me? Hello?
Proceed, Honorable Masuta.
Hello, can you hear me now? We've just started with load shedding, so the network
can hear
will be
you, proceed.
disturbed again.
We can hear you, proceed.
No, I was just saying that, Chair, what you have just summarized now, can it go into the report of the committee to say that it's not that we necessarily think this idea is completely out of sync, but we think that it is a matter that can be deferred for future consideration. So the context in which construed.
Okay. We are losing you again, Honorable Masuta.
No, I've made my point, Chair, that,
Okay.
that
No, thank
it should go into the record. What you've just said last should be
Okay.
recorded, that this is a matter being deferred for possible future legislative development
Okay,
or
thank
policy
you.
development.
Okay, thank you, Honorable Masuta. Honorable Doctor, your hands is still up.
Sorry, Chair, I think it's a legacy hand. My apologies.
Okay, thank you. Honorable Mohotu.
Thank you, Chair. I only wanted to say that I also concur that Section 39 should be excluded from the bill for now. Thank you.
Okay. Thank you very much. Can we then move to the draft A list parliamentary? Can you take us through?
Yes, Chairperson. I'm going to just read the A list. Portfolio Committee amendments to the Housing Consumer Protection Bill, B10 2021. Portfolio Committee on Human Settlements, National Assembly. B10A of 2021. Proposed amendments to the Housing Consumer Protection Bill, B10 2021, clause 2. Number 1, on page 8, from line 17, to omit subsection 5 and to substitute the following subsection. 5, the minister may, after consultation with the council in exceptional circumstances, A, on application in the prescribed manner, exempt a person or home, or B, in the public interest by notice in the Gazette, exempt certain persons or homes belonging to a category or a class specified in the notice from the provisions of this Act, either generally or subject to such conditions as may be specified in the notice, but that exemption may not be contrary to the objectives of this Act.
Do we agree with the clause 2?
The words, the last words, may not be contrary to the objectives of this Act. Whether that would not be defeating of the purpose of this provision, of this exemption, because the objective of this Act may be construed as precisely regulating everybody. So I don't know what that means. Well, I know what it means, but I don't know what it doesn't mean, perhaps, to put it that way. If I could just be clarified to avoid any risk of contradiction.
Okay. Honorable Makgoto, is it the legacy hands or do you want to speak on clause 2?
Oh, sorry, Chairperson, it's a legacy hand.
Okay, thank you very much. Can we get clarity, parliamentary legal services on what Mr. Masuta has raised? And then
Askisi Chair, can I say something before?
okay, all right. Mr.
Chair, I think if because I assume that this A list was written by both our legal, that means Parliament legal team and the department's legal team. That's my assumption. So when they read these amendments, exclusion and inclusion, if they can just give a minute explanation what informed that, it will be easier. Because to me, what Member Masuta is asking, it's in line with exactly why do you say this? There must have been a reason. So my view is that if we could start there, and then I think it will move smoothly. Thank you.
okay, thank you very much. I don't see any other hands. The legal teams.
Chair, if I could assist the drafters in answering my question by making a counter proposal of the formulation so that when they answer, they consider my counter proposal. Would that be in order, Chair?
I didn't get you, Honorable Masuta.
I'm saying that to assist the drafters in responding to my concern, am I allowed to give a counter proposal in terms of an alternative formulation and let them consider
let's
it
get the
in answering?
explanation first. Let's get the explanation first, and then if you still insist, then you can then
Because I
make
thought
that
they could deal with both at the same time to save time.
But can we allow the drafters why they've put what they've put on this clause, and then you will actually be given that opportunity.
All right. I defer you to your ruling, Chair.
Thank you. Can we then have legal teams
Thank you, Chairperson. So members may recall that at the start of our discussions, Honourable Masuta raised the question about the powers of the minister, and it related to how is the power exercised? Is it in terms of a directive? Is it in terms of regulations? And so the state law advisor then explained that the intention is that there were two ways in which this power would be exercised. One would be by way of an application, and then two, so that would be application specific, and two, it would be more generic, and it would be done in terms of a government gazette. I'm not sure if I've clarified it. And so this is how we felt it would fit if we worded it like this. However, we are happy and open to input and suggestions, and it's very welcome. If any of my colleagues want to add, in case I've not been clear, please do so. Thank you.
Yes, supported, Chair.
Honorable Masuta.
Chair, I suspected precisely that if I had offered a counter formulation, it would save time, because what they've repeated what is not at issue in my question. In other words, the answer is not relevant to my question. I'm not dealing with that issue. That's why I wanted to assist. So let me try and assist again. I am finally, I'm happily comfortable with the formulation, but the question is not related to that. The question I asked relates to the very last phrase in the entire clause, which is basically saying that whatever exemption that the minister makes should not be contrary to the aims and objectives of the Act. But as I understand it, the aims and objectives of the Act actually negate the purpose of this. So it's a contradiction in terms.
Honorable Masuta, I don't know what the other members hear you. I don't hear you.
And that was the issue. And that's alternative formulation that they can consider so that they agree or disagree with it. Chair, are you still not hearing me?
No, we can
Hello,
hear
are you
you.
still not hearing me?
We can hear you, Honorable Masuta. Can you write it on the chat, and then they will read it to us, and then we'll then take it from there. Please write it on the chat, because we're struggling to hear you.
It's a bit tricky for me to do that. Let's just pass it, Chair. I mean, let's deal with other issues. This communication issue is just making it difficult for me to participate.
Sorry, TK.
Thank you.
I think I'll just let it go. But I do think that there is a legal problem here. But yeah, maybe we'll find another way of dealing with it offline.
Okay. Okay, Mr. Masuta. Honorable Doctor, and then followed by Mr. Masemola.
Thanks, Chair. I hope I'm not out of order. Chair, I think I would like to suggest, I probably am out of order, you'll call me out of order, but I'd like to make a suggestion that we consider, I know it's the end of the year, that we start meeting in person. I think, the challenges that we face with the technology, can to a certain extent put the work that we are doing in jeopardy, because everyone's inputs are so important, and yet we are unable to deal with some of these challenges. So I just want to suggest that so that we can, all benefit from the discussions as well, because we would all like to hear what all the members would like to say, and not have anyone say, oh, well, let's just leave it, because it could be something very important to the work that we do. So just a suggestion on the side there, Chair. Sorry if I'm out of order.
You are really, Doctor, because like at the time we called the fiscal meeting.
Chair, are you able to hear me?
Honorable Masuta, can we give other comrades a chance, honorable members, to deal with the issues that you have raised, and then we'll because you are saying you want to submit a what?
I'm saying maybe I'll
Reconstruct
have
the
to talk
sentence.
to them offline if they will hear me.
Yeah,
But it's just
that's what-
administrative nightmare to have to okay. I
Okay,
don't know what
no,
else to do.
No, you'll talk to them. They will call you a legal person.
It was
from
going to be a
Parliament.
very simple solution that would take us forward. But anyway, it's fine. Let me just surrender. It's okay.
You don't have to surrender, Honorable Masuta. You can talk to them. This is still a draft. We're still going to have an opportunity to make our inputs. If you have a problem with the network, in 2 hours, I think probably your load shedding would have ended, and then you can come in if the meeting is still on. And if you are still having some difficulties, you can actually interact with the parliamentary legal service person, and then your issue would then be brought to us, and then we can then engage on it. Can I then get Mr. Masemula?
Thanks, Chairperson and honorable members. The part that Honorable Masuta is mentioning is that the intention there, which says it's to ensure, because we must also remember the objectives of the bill, or rather it's nothing else but to protect the consumers. So any exception that is being done, it must not be contrary to protecting consumers themselves. So that is the intention of that part. Thank you. Even if you allow an exception, it must not be in such a way that it doesn't protect the consumers. That is the intention. Thanks, Chairperson.
Thank you very much, Mr. Masamula. Mr. Masamula is the acting legal officer of the department. So not at some point somebody said it's from the ministry. It's been appointed as the acting legal person of the department. Honorable, I don't see any other hands.
So, Chair. Hello.
Yeah. Hello, Honorable Masuta.
I don't know if my participation is
Honorable Masuta, we can't hear you.
Creating this difficulty that each time I try to give input, I become inaudible. I think I'll just
now
have
we can
to
hear you.
stand back and listen.
Now we can hear you.
Yes, I'm saying precisely because of this problem of not being heard. Maybe I should step aside and not.
Chairperson.
Yes, I'm saying because of this. Yes, I'm saying because of this on and off hearing of me, I'm going to step aside and just listen and not participate at this stage
Honorable Masuta.
because it's not going to be
Honorable Masuta, I'm
helpful.
saying, Honorable Masuta, I'm saying the load shedding
There
will,
is a break, just to
Honorable
indicate
Masuta,
that hopefully I'll be allowed my own input because I realize it's a futile exercise. My attempt to make a contribution is not working. So I'll step back and just
Honorable,
listen. Yes,
Honorable Masuta,
you still can hear me.
you can listen.
Yeah, I hear you very clearly, but you don't allow me to step back.
I'm saying,
Allow the process to run and
no, I'm saying, Honorable Masuta, the load shedding within 2 hours, it will have finished, and therefore you would then you're still going to, at that time, you can then come back and say and clarify what you want to say, because this is still a draft, and we're still going to debate on the draft and agree on it before we proceed to another B list. So can we agree on that? Honorable Masamola and Dr. Kumal, I see your hands up. What is it all about?
Legacy hand, Chair, sorry.
Honorable Masamola, or is it two legacy hands? So we are parking clause 2 and then we'll then finalize it later when Honorable Masuta were able to hear the input, and maybe I should ask the legal or the state law advisor can actually call Mr. Masuta to, and then so that he can then be privileged on the what you were saying. Can we then go to clause 7?
Chair, I don't have Mr. Masuta's numbers as a state law advisor. Can I propose, Chair, that Mr. Masuta, if possible, I don't know if he'll be able to use the chat on the platform, Chair, to communicate his proposal.
That is what the difficulty part of it is. He's not able to do that because he's partially blind. That's why I'm saying somebody must call him. And
yes.
Koliswa, can you
and it's
please
just
explain?
cumbersome, Chair, to have to redraft a whole clause. It's just too much work. It should have been simple just to explain the point. But like I said, I'll
Now
wait
we
as you
can hear you.
suggested.
Yeah. Koliswa,
Now, I
can
was
you
just saying, Chair, I'll wait until such time as I'm able to explain to them what formulation I'm proposing, because I think it's a very simple way to come around this problem that would actually solve it. But I'd rather not continue to attempt and then the next thing I'm not heard. It's just frustrating. I'll not use the chat because it means redrafting whole clauses, and I don't think it's too cumbersome. It's not something you can just do in 2 seconds.
That's why we're saying, Honorable Masuta, we request the state law advisor, Koliswa will send them your number, and then they'll come back, and then they'll come back to the meeting and direct and make that input on your behalf, and then the meeting will then discuss on it. That's why we're not taking any decision on it. We are parking it.
Yes.
Clause
No,
7.
I heard you, Chair, and I agree with you. It's fine.
Clause 7.
Clause 7. So members may recall that there was a discussion about the vacancies and the filling of the vacancies. And so clause 7 attempts to deal with how we do that. So clause 7 reads, I'm just going to read the clause 1 on page 9 in line 29 after the word office, to insert taking into consideration representativity, expertise, and previous performance. So this talks to the existing 7.1, which speaks about the member of the board holding an office for a period of 3 years, and then it talks about the reappointment, and it talks about reappointment at the expiry of the term. And then we've tried to bolster that clause by saying what would need to be added to look at the reappointment. 2 on page 9 in line 42 after expiry, to insert within which period the minister must appoint the replacement. So we've inserted that to address the concern about the gap, about the time frame there.
Thank you very much. Members, do you want to talk to that? Agree?
Chairperson, it's Honourable Powell. I'd just like to ask how the revision addresses the specification of a time period by which those vacancies must be filled. That was the issue that was raised. It still is somewhat open-ended, and I think that when we made the submissions last week, the concern was that we've seen this phenomenon occurring in the department that board positions stay vacant for long periods of time with acting acting board members. And so we had asked that there was a specific period of time, 6 months, 2 months, 3 months. And I'm just concerned that I'm just looking at what's here. It doesn't address the concerns that were raised by the committee. We had asked for a specific time period.
Chairperson, if I may.
Yes, come in.
I hear Honourable Powell with regards to wanting a specific time period in there. As this is our very first draft, we can look at a time period which is reasonable. The State Law Advisor may want to add.
The State Law Advisor.
Thanks, Chair. On 7, Chair, the time period is there because it says, if you look at line 42, Chair.
Does not exceed a period of 6 months.
On page 9. So there's a period of 6 months there within the acting person. The person that has been appointed to replace is appointed chair. And then, so we're saying within that 6 month period, then the minister must appoint the replacement chair.
Okay.
So the period in as far as we are concerned, Chair, is clear there. Thanks, Chair.
Okay, thank you very much. Honorable Powell, I see your hand.
I'm just reading it. I just wanted clarity that at 7.5, notwithstanding the period of the term of office referred to in subsection 1, any member holds office until the minister has appointed another member to replace that member, after the expiry of his or her term, provided that such a period doesn't exceed a period of 6 months after such expiry. I hear what the state law advisor is saying, but I'm just concerned if you read the 7.4, it says that the minister must fill the vacancy for the unexpired part of the period for which his or her predecessor was appointed. So let's say somebody resigns with 6 months of their term left to go. The 6 month provision after such an expiry, it means that that vacancy can still remain open for half a year. So I'm just wondering if it may be prudent for us to maybe tighten, so to specify a time period in section 7.4. I do see that there's this not exceeding 6 months, but we're still essentially leaving a gap open that the board position may be vacant for 6 months. And I think that that's what we need to tighten. I don't know if other members of the committee have got inputs on it, but 6 months is quite a long time, Chairperson.
But if you understand the process, 6 months is even little, because what should then what would happen is that the minister would then be able to, he must advertise, and then there must be a shortlisted, then they appoint the appointment committee and blah blah, and taking into those considerations, I think the 6 months is fair. Honorable Tseki, I see your hands. We have lost Mr. Tseki. We'll give him a time when he comes. Oh, now he's back. Honorable Tseki.
I was thinking that I think based on the questions that are raised, I would want us to support this amendment and to move to the next one.
Oh, I've muted myself. So I was saying that we should agree that 6 months is not long. Taking into consideration the process that must unfold after the vacancy has arisen. Can we then agree that 6 months is fine, honorable members, as Honorable Tseki's proposal?
Chairperson, if the committee agrees, I'm happy for that to remain then.
Okay, thank you. Clause 11.
Thank you, Chairperson. So the thinking behind clause 11, members had raised concerns about the frequency of meetings and that we should specify a minimum amount of meetings. And so clause 11 was our attempt to address that concern. I'll read the clause. 1, on page 11 from line 2, to omit subsection 1 and to substitute the following subsection. 1, the board, A, holds meetings at such times and places as may from time to time be determined by the board, and B, must hold a minimum of 4 meetings annually. Thank you, Chairperson.
That's the issue.
Agreed, Chairperson.
Agreed. Members,
Agreed,
do you all agree? Thank you very much. Let's go to clause 15.
Clause 15, if I may just have a moment. So clause 15 deals with the appointment of Chief Executive Officer and Chief Financial Officer. And the concern was to, sorry, just bear with me for a moment. So the current section after line 29, just bear with me. It says a person appointed as Chief Executive Officer or Chief Financial Officer must have qualifications and experience relevant to the functions of the council. And so what we've done is we've inserted the words after council to insert as determined by the board. So there was a concern about the qualifications and the experience and what that would entail. And so we've literally inserted as determined by the board. So the board will be in a position to determine what qualifications, expertise, and experience the CEO and the CFO would require, without being too prescriptive. We had a whole discussion about what we could possibly include, and it is quite difficult, because if I were to just give members an example, so for the position of Chief Executive Officer, if we were to say, for example, they must have a legal requirement, I mean, that is quite prescriptive, and many attorneys may not want to serve on the board, for example. And we felt that the board would be in the best position to decide what caliber expertise they would want in their CEO and CFO. My colleagues may add, should they wish. Thank you.
State Law Advisor.
Can I comment, Chair?
Okay.
Yeah, I think the emphasis here was on the powers. That's why we inserted determined by the board, because we didn't want to leave it with the council only. You know, whatever the council does, the board should have superseded those decisions or given guidance of those decisions. Thank you, Chair.
Honorable Powell.
Thanks, Chair. So I hear what the advisor is saying in terms of not being or not wanting to be too prescriptive, and the range of varying expertise that may be required for the position of the CEO or the CFO. Now, the discussion that we had was in relation to the DPSA framework and the alignment of the position with the qualifications required in terms of the remuneration guidelines. If I draw the legal advisor's attention to section 6.3 of the bill, where we discuss the composition of the board, the drafters of this piece of legislation have very adequately listed in provisions A to J the range of knowledge and expertise that are required for board members. So my first question would be, if it is, if this bill is being prescriptive in terms of qualifications, knowledge, experience by board members, why is it not possible to do the same for CEOs and CFOs? Then in respect of the example given around, for example, whether or not the CEO needs legal skills, one would imagine, if one looks at a CFO, that a CFO managing the finances of the council would require a degree, for example, in chartered or management accounting. Now, those are basic minimum requirements that any CFO should have. The problem that we have is that we, when making legislation, need to imagine the worst possible scenario in terms of political governance. So you've got a politically appointed minister, and let's just look at a dystopian scenario where we have a politically appointed minister who serves on behalf of the president, who himself is elected by his political party. We've got that politically appointed minister then appointing the board members, which could be done from a range of unqualified cadres. And then we've got those unqualified, I'm talking about a potential dystopian scenario, we've got those unqualified cadres then appointing or determining the criteria and the qualifications upon which the CEO and the CFO, we could end up with a politically captured, incompetent and inept management, which is why when we write legislation, we need to envisage the worst possible scenario and we need to be prescriptive. So if the question remains, if it was possible for the drafters of this legislation to stipulate experience and knowledge in respect of the composition of the board members in section 6 of the bill, why is it not possible to at least list minimum competencies or explicitly defer to guiding legislation or guidelines in terms of, for example, even making reference to the DPSA, the remuneration guidelines framework? I don't accept that it is not possible to be prescriptive here. It is certainly possible to be prescriptive where a CFO is concerned. And I don't think that the concerns that we raised have been covered by inserting a clause that says as determined by the board. Especially given the range of scenarios that potentially confront our country after 2024. Thanks, Chairperson.
Thank you very much, Honorable Powell. Can we get the response from the
Chairperson? I've just raised my hand, please.
Okay, but it's not visible, Honorable Mohoto. But you're welcome to make input.
Okay, thank you, Chairperson. I agree that the bill should also include that there should be minimum requirements that are needed for a person to occupy positions such as CFO and CEO. For example, qualification is very important. Experience is very important, skills are very important, and the knowledge of, that particular work is also needed. And it should be stipulated in the bill. Thank you, Chairperson. Chairperson, thank you.
Thank you very much, legal team.
Thank you, Chairperson. I've noted Honourable Powell's submissions, and while I've used the word prescriptive, I didn't say that we have to be prescriptive. That wasn't what I was trying to say. I said we didn't want to be too prescriptive, but having heard the comments from the members, we'll take that into consideration and recraft to insert minimum qualifications subject to anything else that my colleagues may want to add.
Subject to the public administration framework. Because there is a framework that you have in this country. Can I then get the state law advisor?
I've got nothing to add on the issue, Chair. Thanks.
We do agree, honorable members.
Chairperson.
Honorable, yes, Mr. Masemola.
Thanks, Chairperson. No, I think we agree that we'll go back and work on it. Just to indicate that the CEOs are not really governed by the PSA, but it's something that we'll work on and enhance what we have, as honorable members were indicating. Thanks.
Okay, thank you very much, Mr. Masemola. Can we then proceed to, is it close 16?
Thank you, Chairperson. So there was a concern around clause 16 that dealt with the possibility of concurrent terms, you know, ad nauseam. And so what we've done is we've inserted the word only to address members' concerns. So now it reads as on page 13 in line 34, after the words for, it will now read for one additional term of 5 years only. And we were of the view that that would have closed that gap. Thank you, Chairperson.
Thank you very much. Agreed, honorable members. Silence means that members agreed. Let's proceed to clause number 32. Honorable Zeki.
Agree, Chair.
Okay. Clause 32.
Thank you, Chairperson. So members will recall that there was a concern relating to the MMC and the MEC being involved with the release of funds in relation to housing projects. And to address that concern, so we've noted the concern, we understand where the concern comes from. Obviously, we don't want political parties having direct, not political heads, having direct access to this sort of power. And so what we've tried to do is we've tried to recraft clause 32 by removing 32(1) in its entirety. So it will no longer read that a MEC or MMC or his or her delegate may not release any funds in relation to any housing project unless the requirements of this act have been met in relation to that project. So we've removed that completely. And what we've put is an MEC or MMC or his or her delegate must ensure compliance with this act in relation to a subsidy or social housing project. So we've attempted to create that complete separation and distance. My colleagues may add if they wish to. Thank you, Chairperson.
Thank you. State Law Advisor, or Mr. Masemola.
Thanks, Honorable Chairperson. I think the concern that was raised, I think Honorable Heron, I think it was taken into account. Indeed, it might be in contrary with the Public Finance Management Act, in that the responsibilities of finances will not be with the MMC. So we thought it is important that indeed we recraft it and remove the responsibility where legally it may not be supported. That's the reason why it was changed to this one. Thanks, Chairperson.
Thank you, Mr. Masemola. Honorable Powell.
Thanks, Chairperson. I'm still concerned about the section 32, because ideally what should happen is that the relevant administrative official who deals with the project pipelines, the contractual agreements, the procurement, the risk management, and the delivery of social housing projects at an administrative level, who carry fiduciary responsibilities or have fiduciary duties in terms of the PFMA and at the municipal level, the Municipal Finance Management Act. Those are the responsible parties in law. Now, I understand that this is an overarching clause that says an MEC or an MMC or his or her delegate, but ultimately it is the responsibility of an MEC and an MMC. And I think I'd like to just pause here and say that in an executive mayoral system, the MMC carries delegated powers of the executive mayor. And there are varying systems and arrangements that can happen in terms of MMC cabinets. This is, I don't believe, satisfying the Honourable Heron's concern that this provision may render this bill ultra vires in terms of duties that are already established in terms of the finance management laws that govern our country. So would it not, and this is a legal question for the legal advisor, would it not be more prudent to remove the reference to MECs and MMCs in its entirety and rather substitute this clause with the relevant provincial director general, or you could even say national director general, provincial director general, and a municipal manager or executive director at the varying levels of government? I'm just concerned that we're placing a duty on a political appointee when it's really the municipal manager and the director of a provincial department that carries that duty in law to ensure compliance. I hope I've made myself clear, Chair.
Thank you, Honourable Powell. But mine is that in terms of the same PFMA, MECs and or a particular council, they have a responsibility to oversee the finances of the of the department. Actually, it's even specifying that on monthly basis, the CFO and the CEO must brief the MEC and I'm talking about the PFMA and the Public Service Act in terms of the powers of the executive. So it's put it very clear that an MEC has to be briefed on monthly basis about the finances of the department. And for me, I think it suffices to say that they have again responsibility
Chair, my hand is up. Chairperson, are you there? Honourable Semenya, are you there?
Hello, Chairperson.
Khaliswa.
Hello.
Hi, can you maybe phone the chair? It looks, I think she's just dropped off the platform. Maybe, what's the time?
The network.
11
Okay,
o'clock, yeah. We might need to elect an acting chair.
It's the same network problems.
Yeah.
We're all victims of this network issues.
Chair is reconnecting members. Can just please give him some few minutes.
Thank you very much, honorable members. I think I got cut. I don't know what's the problem. So I was trying to say that in terms of the PFMA and the Public Service Act, give ministers, MECs, ministers, MMC responsibility to oversight on their budget. And therefore, if the Act says the MEC or MMC or his or her delegates must ensure compliance with this Act in relation to the subsidy or social housing project. For me, it suffices. Honorable Powell.
Thanks, Chair. I hear what you're saying, and I completely understand that MECs and MMCs are responsible for oversight functions and for guiding and steering the programs and the projects of the department in line with the political vision of the party that they represent. But I think that predominantly the function of implementation of legislation and compliance with legislation is a function of administration. And for example, executive mayors already derive their functions from existing legislation in terms of the Municipal System and Municipal Structures Act. It's essentially an oversight function. And I'm not committed to this. I'm not going to make a further contribution. We've got lawyers in the room who can advise. I'm just concerned, ultimately, that this provision places the compliance obligations at the foot of the wrong persons, that this compliance obligation should be given to administrative officials and not politically appointed leaders who are responsible for oversight and vision. Thanks, Chairperson.
Thank you, Honorable Powell. As I'm saying, the Act gives them the powers, and MECs and MMCs, they are the ones that appoint these officials. They'll have to see that they appoint correct people and monitor the work that they do. That's my view, of course, because the Act says they has to oversight on the finances and the strategic plans of their department as the executive, because sometimes even MEC employ a wrong person, he must take responsibility. So, or the executive mayor must take the responsibility through his appointed MMMC. So maybe let's get the lawyers to advise. Parliament and state law advisor.
Chairperson, sorry, Cesar, do you want to?
Yes, I'll go first.
Okay.
Thanks. Chair, we agree that this is an oversight role, Chair, that is played by the MEC and the MMC. And if we look at the other pieces of legislation that are involved in the provision of social housing, Chair, for instance, the Housing Act, it has a huge role for the MEC, and the role that is played by the operational people, Chairperson, won't be taken away from them, but the oversight role of the political heads would still be there in terms of this provision. So we're not being prescriptive. That's why we removed that provision that said they must ensure that funds are not released. So we only now placing the oversight role on their shoulders, Chair. Thanks, Chair.
Parliament.
Chairperson, I was going to say what my colleague has said essentially. Thank you.
Honorable Masuta.
Chair, I don't know if you hear me.
Yeah, we can hear you clearly. It's your network back.
No, it's not back. You see, what happens is that when is load shedding, the network comes back and forwards. So sometimes I'm clear, sometimes it goes away.
Okay, make your input when it's still clear.
Yeah, no. Because I got cut out, I got lost as to where we are, and I just wanted to clarify: are we talking about oversight powers, or are we talking about delegation powers in relation to the allocation and use and accountability of funds between national, provincial, and local, or what is the specific loss that we're dealing with? Sorry to take you back. I got completely taken out of the system.
Thank you, Honorable Masuta.
I'm trying to understand what the issue is.
Okay, let me give the legal people to expand on their answers so that you can then hear them.
Thanks, Chairperson. May I proceed?
Let's proceed, Mr. Masamola, and then followed by the state law advisor, and then the last person will be the parliamentary legal service.
Thanks. I'm sure it's just to repeat for the purposes of Honorable Masuta, just to explain, as he says, he might have missed what was the issue. Honorable Masuta, there was on the initial one, it talked about MEC or MMC not releasing the funds. Now, looking at the PFMA, it creates a problem that it's not really the responsibility that would fall within the political heads to do that, to release funds. So we have realized that it might really be a challenge in having that kind of a clause. That's when we then decided to change it to a stage where it only acknowledges the oversight role of the political heads, not to be involved in the releasing of funds. That is the intention, and that's why the subsection was, or rather the section was redrafted as it is now. Thanks.
Sorry, Chair, just is that not the responsibility of the treasury of the province, as is the responsibility of the treasury of the national government to release funds to specific departments, and upon funds being released, they become the responsibility of the accounting officer to administer the funds once the administrative officer is, the accounting officer has received the funds. And of course, the political head at national or provincial, possibly even at local role, would, as seems to have been suggested, to exercise oversight over the appropriate utilization of those resources once released. I'm trying to understand, I'm trying to follow where the discussion is at. Pardon me for interjecting.
Chairperson, exigence.
Yes, Honorable Tseki.
While I sympathize with the avoiding to deal with broad or general issues, because here we are inserting and deleting on what has been written already. I know the state of Comrade Masuta. I'm not sure how we could assist, but currently it's not really taking us forward, Chair. I want to pardon and be sensitive on his status. Thank you,
Okay,
Chair.
I withdraw my question then, Chair. Thank you. You can proceed with your discussions. Thank you.
Thank you, Honorable Masuta. Can we then have members to agree that the inserted clause has actually dealt with the challenge that honorable members had, because in terms of the Public Service Act and the PFMA, executing authority, they have a responsibility to play their oversight. And the legal team has, and they must be accountable on their department and their councils.
Chair, my hand is up. I'm not sure if you can see it from your side. It's been up.
Oh, I didn't see it, Honorable Doctor. I'm sorry.
No problem.
Honorable
No problem.
Doctor.
Thanks, Chair. No problem. I just wanted to see if I could offer, because I understand both. I mean, from where your understanding is and where Member Powell's understanding is on this clause or this insertion. And I wanted to maybe propose that maybe this should read an MEC or MMC or his or her delegate, maybe not even his or her delegate, must ensure sufficient oversight to compliance. I think that will then ensure that in as far as your input is concerned and your understanding is concerned, it covers that, and as well as the little bit of a concern that maybe Member Powell has. I think then it takes away the ensure, almost kind of puts the responsibility. I think the understanding is that they ensure compliance, which is correct. MMCs do ensure that the department complies, etc., but not in the active implementation of that compliance, but rather from an oversight perspective. So I thought perhaps to offer some way forward on this one, we could use the word oversight between ensure, must ensure through oversight or sufficient oversight compliance with the Act. So that's my submission to ensure that everyone is covered in that regard. Thanks, Chair.
Thank you, Doctor. Honorable Masuta, your hand is still up. Okay. Doctor, your hand is still up. Is it Lika's hand?
Yes, Chair, sorry. I must remember to lower it every time I spoke.
Can we then have the legal team to respond on your proposal?
Chairperson, it's Ms. Gangan from Parliament. I have no objection to re-looking at this clause with a view to possibly bolstering it with the addition of the words sufficient compliance and the like, subject to anything that my colleagues may have to add. Thank you, Chairperson.
Thank you. State Law Advisor. State Law Advisor. We've lost Mr. Masemola.
Thanks, Honorable Chair. I think, as my colleague would have said, I think we'll relook at it and just come back with it. I think I don't see much problem, but I think it's something. It's just to enhance it. I think we should be able to.
Thank you very much. Are we happy, members? Can we proceed to clause 41?
Thank you, Chairperson. Chairperson, members will recall that the issue of fees in general was quite a contentious issue in this bill. And members were very concerned by the amount of fees and the like. And the responses were that the fees, as it is in the amendment bill, is in the Housing Act. And what we've tried to do in a way to attempt to address what we could address in terms of fees was to link section 41.5 with section 42. So section 40 deals with fees, and which we've gone through at our last meeting. We went through the entire clause, and section 41 deals with the date and the duration of the warranty. And section 41.5 speaks to the enrollment fee, which says that the enrollment fee must be proportionally adjusted in accordance with the extended period of the warranty cover as contemplated in subsection 3. And so what we've attempted to do is link, like I said, this subsection with subsection above. And so we've literally said on page 20 in line 53, after the words must, we add subject to section 42. So now it will read, Kaliswa.
Sorry, network.
Thank you, Kaliswa. So now it will read, the enrollment fee must, subject to section 42, be proportionally adjusted in accordance with the extended period of warranty cover as contemplated in subsection 3. So, and subsection 42 says that the council must, before making the determination contemplated in subsection 1, which relates to the fees, detail the criteria used to calculate the relevant fee, which criteria and proposed fees must be published by notice in the Gazette for comment for a period of 30 days. So there's the attempt to make sure that the fees are proportional and that it is more transparent in terms of calculation and criteria used to get to the fee. That was our submission. My colleagues may add if they so wish. Thank you, Chairperson.
Addition from the legal team.
Thanks, Chair.
Okay.
Yeah. No, Chair. I think the parliamentary legal advisor has clarified it, Chair. It was mainly to deal with a concern that was raised with regard to that provision, 41, Chair. So we just linked it to 42 to make sure that the same process with regard to the adjustment is followed. Thanks, Chair.
Thank you very much. Honorable Powell.
Thanks, Chair. Two things. On this A list, I've got this A list in front of me, and I've also got the draft bill in front of me. In terms of clause 41, you say page 20. Page 20 of the draft bill is section 8. The page number of the draft bill that we were sent is page 40. And that page 40 is where it covers section 40. and section 41. I don't know if we're looking at the committee is looking at a different piece of legislation. Page 20 is way back. It's section 8. Then in terms of substantive submissions, so we'd raised the issue of just the financial burden on especially small and emerging home builders having to pay a once-off registration fee, an annual fee, and an enrollment fee. And I looked over the submission by the Master Builders Association of South Africa again this morning. And I mean, that association represents more than 4,000 contractors and employers in the industry. And on page 3 of their submissions to the department and to the committee, they raised a concern around enrollment fees for minor alterations, creating an administrative burden for the regulator, which is already not coping with enrollments. I see that someone's, I think, Paul, you're not muted. I understand that you've now made this subject to CPI, which is, I mean, it's something, but it doesn't address the concern by the Master Builders Association, as well as my concern, that if we're going to be charging enrollment fees for this act, which now covers minor alterations of any kind, that we're creating a financial and an administrative burden for specifically emerging and small home builders, given that they've got to pay the registration fees and the annual fees as well. Now, this is not a wording issue. This is a substantive issue for the committee to deliberate on. In the interest of developing and promulgating pro-poor legislation, would the committee consider waiving at least one of the 3 fees for minor alterations? I just want to find out what everybody on the committee feels about that, because I mean, 3 separate fees for, if you, for example, putting a door frame in, or bashing a window, to make space for a guest bathroom, something small like that. I just think that these are, we need to take into consideration the submissions of the industry, especially an association as big as the Master Builders Association. This is not a legal issue for response by the legal advisors, rather it's a substantive issue for committee deliberations. If we don't accede to the requests of the Master Builders Association, I think we also just need to take cognizance of the potential backlash that we may face by the industry. Those are my submissions. Thanks, Chairperson.
Chairperson, I think we should call order. Member Powell always threatens us when she assumes platform if we are not going to agree with what she's saying. And that's out of order.
Yes, because we are deliberating as members of the committee. You have to convince people's mind. You don't have to threaten them. You are indeed in order, Honorable Zeki.
Chairperson, can you just clarify in what way I threatened anybody during my submissions? I'm saying that we will, given the submissions by the Master Builders Association that are sitting in front of me, that they will, and this is a statement of fact, given that they represent 4,000 different builders, that it is a statement of fact that there will be a backlash. That is not a threat. I'm not threatening anybody, Chairperson. This
it is a threat in that you are.
I am not threatening anybody. I am saying that the committee will face a backlash.
Can you allow me to chair the meeting? You are, Honorable Member. Allow other members to talk to your proposal. What if they agree with you? Why do you have to have that attachment on your input? Because you have not even listened to what
I'm free to make any submissions to the committee that are in line with the rules of Parliament, saying to the committee that we must take into cognizance, and I've asked for the inputs of other members, but to say that I'm sitting here with the Parliamentary Portfolio Committee presentation that was given to us by Roy from the association, who's the executive director. He has said that they don't support this. They represent 4,000 people. It's a statement of fact that there will be
but it's
not a threat to anybody.
It's their words. It's their words against. We're not sure of that. We've
I'm
never
asking
received that.
for a
Why do you
deliberation
want?
by the committee,
No,
Chairperson.
honorable. Yes, but when honorable members they are saying they feel threatened, indeed, you are actually channeling them. Why do you have to do that? Allow them to speak on your proposal.
Chairperson, you
if they
can't
agree.
censor or edit the style of my submissions. If you are going to rule me out of order in line with the rules of the National Assembly, can you give me
because now you are
specific
exchanging
rule?
on me, and if you are not happy with my rulings, you know what to do, honorable member.
So have you ruled me out of order for saying that the committee will face a backlash?
Yes, that's what
on
I've
the
said.
basis of that's fine, Chairperson, I will abide by your ruling, but I'm asking in line with which rule of the National Assembly you are ruling me out of order. Can you give me the rule as you need to in terms of the rules?
Honorable, I don't have the rule book with me, but
And
you
you're
know
chairing
that
a meeting
if no honorable
Parliament,
Powell,
you don't have the rules book.
I have, honorable member, is that I'm saying to you, honorable Powell, if members they feel threatened by your inputs, you don't have to attach that views. Allow them to debate on your matter, and if you don't, if there is no agreement, you will then be able to. And we as members, we have the right to differ as members of the committee. So can I then get other members speak on what Honorable Powell is suggesting, that let's waive any other, let's waive the one of the registration on the minor alterations. Can I get input from members? Doctor?
I'd like to just agree with Member Powell, Chair. Thanks.
Thank you. Members, can we get your views on the matter?
Chair, my apology, I'm trying to connect.
Okay.
Chair, in our previous statement, we did raise the issue. I was one of those that listened very carefully to MBA. And they told us about the cost. And I'm not representing MBA like Member Powell. I'm saying based on their advice, they said to us, it would be costly to do a number of things. And my view was that before we could do that, could we have a research that convinced Parliament in line with their proposal? Because they made a submission, Chair. And my view is that we can't just ignore, because they were even saying the cost will also be embedded to the same people that we seek to assist. So mine would be, let's suspend it, Chair, until we get a proper advice. This one may not just be a legal advice, but it's going to be a financial advice. I'm not sure Parliament, whether we do have that capacity, but I would propose that in that line, Chair. Thank you.
Thank you. Honorable Doctor, your hand is up again. Honorable Powell, your hand is still up.
Thanks, Chair. I just want to be clear in terms of the concern. So if it was that funds, we're talking about having 3 fees, an annual fee, a registration fee, and an enrollment fee. The proposal that is on the table from my side is that we as a committee consider waiving the enrollment fee only in respect of minor renovations and alterations. The concern being that funds collected for the enrollment of home consumers that arise from alterations or renovations that are minor will in fact be funding a warranty for major defects. So to be clear, my proposal is that we insert a provision in respect of section 40C that speaks to the waiving of an enrollment fee for minor alterations. And then just to motivate it from a financial sustainability perspective, I hear Honorable Teki's suggestion that some kind of a funding feasibility study is conducted. So I'm just looking, but I think, okay, so to motivate it, if we go to section 34, funds of the council, we note that the council will now have an additional revenue source, and that will be in terms of 34D, which would be an appropriation from Parliament, which they previously didn't have. So perhaps the one waiver of an enrollment fee for minor alterations will be adequately offset by an appropriation from Parliament. Thanks, Chair.
Thank you very much. Honorable Zeki proposed that we park the matter because we're still going to discuss it. Let's come back to the matter as we finalize the bill. Can we then proceed to close, is it 88?
Thank you, Chairperson. Clause 88.
Let me get Mr. Masamula's hands is up.
Sir, I had
And
raised my hand,
Advocate
Chair. I
Masutha.
think it got lost.
You have Mr. Masutha. Can you come in and then we'll then get Mr. Masamula?
Yes. Right at the beginning of this exercise, I indicated that key the bill, and I realized that some of this work, it may have been done so on. We talked about implicating other departments and state entities. It's one of the items. Another item is financial implications of the bill. So under financial implications of a bill, you list all the financial implications of the bill in one place so that you have a holistic picture of what is the financial implications of the bill going to be, including where such financial implications will require or not require the concurrence of, as a matter of picture, where all the clauses that relate to the charging of fees, the financing through appropriation, and what the overall cost of implementing the bill is going to be. I raised this at the beginning, and I don't know how we're going to consolidate all of this, because the way I see us doing this is in a piecemeal way. We're going backwards and forwards. This, do we like this? Do we like that? But we're not dealing with it in a holistic picture. So I would like the department and the committee to really reflect on this going forward and see how best we can deal with it in a more scientific way. Thank you, Chair.
Thank you, Honorable Masutha. That's why Honorable Zeki said, let's pack this matter and then we'll come back to it again. Can I get Mr. Masamula or the legal team?
Thanks, Chairperson. I just thought I must just indicate that indeed the intention of the enrollment is to ensure that the warranty is available for the consumer. Now, I'm not sure what Honorable Powell means when she talks about the minor, but this act will apply when the alterations or those renovations that are being made, they require that there must be a submission of building plans to a municipality in terms of the National Building Regulation and Building Standards Act. So there will be those minor things that would be done, but they don't need to be enrolled. But those that means that you need to have building plans, it means there's a change in the actual plan of the house, which needs that kind of registration, which therefore requires or warrants the need of you ensuring that the structural of the house is still intact. So that's my submission on this issue, Honorable Chair. So minors are still somehow covered for not being enrolled. Maybe, Chair, to indicate where that.
We're listening, Honorable Mr. Masemola.
Thanks. On section 2 or clause 2, subsection 1B, it talks where there's a need, when there's I'm just referring to the clause that I was talking about, where it indicates that this is when it's necessary to enroll it. It's not for every just minor alterations. Thanks.
Okay. I think the issue is that we're agreeing that we pack the matter. We'll actually finalize it when we deal with the A list again on the matter. Can we then proceed to clause 88?
Thank you, Chairperson. Clause 88. So clause 88, for the most part, is just technical amendments, save for 4, 5, and 6. So on page 36 from line 52, we've taken out the word and we've just substituted with a semicolon. And I understand that that's in line with drafting conventions. And on page 2, on page 36, we've noted that there was no provision dealing with the manner of services, service of notices for documentation pursuant to this act. So we've inserted J to deal with that. Number 3 on page 36 is just a renumbering as a consequence of the insertion of J above. Four on page 36 in line 5 it deals with the rules of the board. We've inserted, and I just want to read for the committee, if I may. So on page 36 in line 5, it says prescribing any manner which is necessary or desirable to be prescribed by the. We had the council and we've changed that to the board in order to achieve the objectives of the act. And then in line with that, 5 on page 36 in line 6, we've done the same thing. Before it used to read council, we've said before the board makes any rules under the section, it must publish a draft of the proposed rules in the Gazette, together with a notice inviting interesting persons to comment in writing within a period stated in the notice, which period may not be less than 30 days from the date of publication of this notice. And then 7, it's the same. We've substituted. Line 12, it said the council may, if circumstances necessitate the immediate publication of a rule, publish that rule without consultation as contemplated in subsection 2. We've changed the word council and made provision for the board. Those are the changes that we've made in terms of section 88. My colleagues may come in if they so wish.
Thank you very much, legal person from Parliament, State Law Advisor, and Mr. Masemola.
Thanks, Chair. I think the parliamentary legal advisor has covered it adequately, Chair. Thanks.
Okay. Mr. Masemola.
Thanks, Honorable Chair. I'm covered.
Okay, members, to agree with the clause? I don't see any hands, means that there is an agreement. Can we proceed to the next clause?
Chair, that was the last one, Chair. Can I just take you back to clause 2, Chair, that we discussed with Advocate Masuta?
Okay.
Yes, Chair. He proposed that at the beginning of that subclause 5, we just we insert basically we remove that that part at the end of just after notice, that part from the comma until act. So he proposed that we remove that part, but that exemption may not be contrary to the objectives of this act. And then to include it as at the beginning of the subsection there, to read, notwithstanding any provision of this act, the minister may, after consultation with the council in exceptional circumstances. So basically, the exception or would go to the beginning of the sentence, Chair, to the beginning of the subsection. So that's where we're going to put it in accordance with that provision, Chair. I just wanted to report back to the committee on that. So basically, it will read, notwithstanding the provisions of this act, then it continues, the minister may, after consultation with the council, in exceptional circumstances, and then it continues until notice, Chair, where the full stop will be. Thanks, Chair.
Thank you very much. Members, do we agree with Mr. Masuta's proposal?
Chair, I assume these are lawyers, so they spoke common language. If the state law advisor and the legal team agrees, Chair, I support them. Thank you.
Thank you, Honorable Zeki. Any other view from members? Honorable Powell.
Chair, when you
And
say, are
then-
there any other views from members, are you speaking with regards to clause 2 or with regards to provisions that haven't been addressed in the A list?
clause 2. I'm still on clause 2. Honorable member, I am audible. Okay, Mr. Masamula.
Thanks, Honorable Chairperson. Maybe I would suggest that as and when we deal with the other parts that are still outstanding, we'll then finalize on this issue and revert on it with the suggestion that is being made. Thanks.
But Mr. Masamula, if members, are you saying you are not comfortable with it as a department, but the committee members through Honorable Seki, they're saying they trust that the lawyers communicating with Mr. Masuta, the input it's valuable. So,
well, I understand, Honorable Chair, but I think my colleague was just indicating what the Honorable member was saying. It's not necessarily that he says he agrees or not. So I thought it might be that we may just find what are the real implications of what does it mean, surely, because if it means the same thing, why must it be removed from where it is? Because normally when drafting acts, this is how it could be written. And I'm not sure. I'm trying to figure out what is really the implication of this. Thanks, Honorable Chair.
State law advice and the parliamentary, do you have any difficulty with the input?
Thank you, Chairperson. So what the state law advisor has, I've got no difficulty with what he's proposed. I must just say that that I also have no difficulty with the way in which clause 2 is drafted. I have no difficulty with that last part. However, I mean, our aim as the legal team is to make this bill as tight and as neat as possible, taking into account members' concerns. I don't feel it changes this clause, but if the member does want it drafted slightly differently and it doesn't change the meaning and the content of the clause, I have no objection. So I'm happy with the clause as it is, but I also have no objection with the change as requested by the Honourable Masuta.
Chairperson, can I comment? I think
yes,
the spirit of this where we find consensus. And it seems as the department is not happy with what the amendment tends to take face. Again, Chair, you've been saying on some of the issues, we will, when we finalize them, we'll have to close. Whether we agree or disagree, I mean, the majority will have to take it forward. So with what Mr. Masemola is saying, it's really not happy. In line with what Comrade Masuta have said, in line with the original amendment as they presented, can we find synergy, comrades? You are the asset of this committee for now, the legal team. So being in the asset of the committee, Comrade Masuta is equally an advocate. I regard him as an asset for the committee in relation to what we are doing. So I would propose, Chair, again. I'm sorry if I'm postponing things, but can we find synergy of that clause? And I think it was said it was the last point, and I want to move in line with what Member Powell was saying, if you agree, Chair. on issues that that have been raised in our meeting, but that are not there in today's A list, which I would request them to be inserted. Thank you, Chair.
Thank you, Honorable Zeki, for the input. Let's agree that the parliamentary legal team and the department and the state law advisor will then be able to bring back the matter for its finalization to us. Agreed?
Agreed.
Thank you very much. This was the last input that were presented by the legal advisor, and just want to check with members whether does these issues represent what your engagement in the last meeting? If you have any other thing to raise for discussion on the bill, which we think it has not been represented very well. Can I get any indication, Honorable Powell?
Thanks, Chair. 3 things. Section 25. Sorry, I'm just looking at my notes. Home builder or developer to be registered. I think that there was a concern that was raised here around the implications of a builder that doesn't register. So in terms of section 28, there is a 1-line statement that says that failure by a person to register or to retain the registration status as a home builder or developer does not affect that person's liability and obligations in terms of the Act. What I'm concerned may be missing is whether or not the work that they perform, so while it doesn't affect their liability or their obligations, the Act, to my understanding, is silent on whether or not the work that they've performed will indeed be covered by the warranty fund. I think that was a concern. Then moving to 29 2B. That's this section talks to the purpose of a register contemplated, or the register that's contemplated, being intended to facilitate a cost-effective procurement process in relation to the building of a home. Now, on reading this bill, it's not clear, A, what is meant by the facilitation of a cost-effective procurement process, to my mind. And I think that it will not be clear to the housing consumer who reads this bill's mind either. Is this prescriptive? Is it merely a guideline? Must it facilitate a cost-effective procurement process that builders will be obliged to implement in their building projects? I mean, what is this? We'd asked for that this 29.2b be clarified. So a cost-effective procurement process guideline, for example, the insertion of the word guideline. Then, without belaboring that point, moving on. Here, I just want to be sure that this wasn't covered. 31.1b. Where construction has already commenced, they must immediately stop construction until given approval by the council to proceed. Now, I raised this, and the concerns that I raised were echoed by a number of members of this committee. We had asked that there be consideration of the inclusion of a minimum period of approval, the burden of which will be placed on the council. So whilst the council here is empowered to essentially stop construction if they haven't issued an approval for the building, what we as a committee asked for was that the council, in the interest of fairness, be prescribed a minimum period for those approvals to be given. And then same section 31, but section 31 2B, I had asked the question around providing financial guarantees. So it says here, the council may, before giving the approval contemplated in subsection 1B, require the home builder or developer to B, provide a financial guarantee to the amount prescribed by the council in relation to that home's compliance with the applicable technical standards. The committee had asked what kind of a guarantee, how much, cash, a bank guaranteed check, what kind of a financial guarantee? Because essentially, if they have been stopped from doing building works, or a condition of the approval is a financial guarantee, we could be stopping small to medium enterprise or companies. We could essentially be hindering their ability to perform works if they're having to provide financial guarantees as well. So we just wanted clarity in terms of exactly how that provision would be executed. Sorry, I just want to look at my notes here to see if there's anything else. I think that's all from me for now. Thanks, Chair.
Thank you very much. Any other input from members? Honorable Zeki.
Thank you, Chair. Just 2 points. On my side, there was an issue of definition of an employee. I think when we are dealing with Chapter 8, some liability of an employee was tabled, and I differed with that liability. That the liability of a construction or of a contractor lies with the owner of the contract, not an employee. So I would request that if we could check that definition of an employee, in particular from what I'm saying. The other one, Chair, we just postpone the costs and the registration. I just want to, I'm not sure whether I'm taking you back, but the legal team will advise us here. And we fill the form of our discussion that would want to assist the beneficiaries of this act. There was a point in many of our public hearings where the contractors were saying, can we give options on this registration? One was that let's avoid annual registration, or maybe do one registration in 3 years. Every 3 years, we do a registration. Or we register as and when we get job. Because others were saying that 2 years, 3 years pass without getting a job, but they have to pay an annual fee. I mean, from where I'm coming from, I found that probably we could look. Of course, NHBRC will advise differently based on their assets and liability as well in terms of the cost. So I would request that if we could, in next time when we discuss that finality, we should also have a view of the implications of this annual registration to ordinary people out there. Those are my 2 points, Chair. Thank you.
Thank you, Honorable Zeki. Honorable Doctor.
Thanks, Chair. I'm not sure we are happy, but we discussed the legislating some controls around our board meetings. So I'm not sure they're not reflecting on the A list. I'm not sure what the rationale or what the thinking is or how we intend to ensure that we legislate some controls over it. I think I raised some of the issues or the reasons why I had raised that particular thing. And I think the CEO position one has been covered. So I'll have that one point, Chair, to just follow up on. Thanks.
Thank you, Doctor, but it was clarified, but there is no transmit. We can allow them to go back to the issue, and then if you don't agree, then we'll see how we deal with the matter. Can I ask the legal team to talk to the issues? Honorable Tseki and Honorable Doctor, your hand is still up. Honorable Tseki. Okay. Let's start with the Mr. Masamola and then followed by legal state law advisor, and then followed by the parliament.
Thanks, Honorable Chair and members. I think issues that would have been raised, I think we'll go back and meet with Parliament Legal Services and state law advisors just to iron them out and then come back with an answer on it. Thanks.
Okay, thank you very much. State law advisor.
Thanks, Chair. I'm in agreement with what is proposed by the department chair. With regard to the issue of 29(2)(b), facilitation, Chair, I think we dealt with that issue last time, Chair. We clarified that it's not prescriptive. All it says, Chair, there's nothing prescriptive. It just tells you what purpose the register will serve. So it's to identify enrolled homes and informing housing consumers thereof, be a cost-effective procurement process in relation to the building of a home. So it's in relation to its use, basically, the purpose that it will serve. So there's nothing in the provision that is prescriptive, Chair, that can be viewed as prescriptive. So it's just to facilitate the process of making it cost-effective. The procurement process being cost-effective, Chair, in the sense that you would know before you enter into that procurement process whether a builder is registered or not, whether they've been wayward in any way, whether they've houses that they've built have been subject to structural defects. So in you having used the register, you'd be able to know beforehand. So I think for somebody who uses that register, it would be cost effective. Well, I foresee it being cost effective in that manner. So it's not being prescriptive. The issue of financial guarantee, I think the council can clarify that one, Chair. The kind, what kind it would be in, and the how much. From where I'm sitting, I wouldn't have that information, Chair. There are certain concerns that the committee has with some issues, Chair, that I think. If you look at them, Chair, these are ideal issues to be dealt with in terms of the exemptions that are envisaged in the Act, Chair. Issues where, where you're saying, I think it was Member Tseki that raised the issue that builders in a certain category would sit for a number of years without getting any work, and they are required to register. I think those would be ideal places where the council would have to be alive to, and then approach the minister to deal with those categories in relation to exemptions. I think that provision in the Act would be the ideal place to deal with them. Chairperson, so I was just saying to the committee chair, they must also have that at the back of their minds, that you have that provision that may be used to deal with these kind of situations that are not ideal for either the home builders and consumers, Chair. Thanks, Chair.
Thank you very much. Honorable Tseki.
When I raise my hand, this thing kicks me out every now and then. Chair, can we be explained what is next? What are we going to do next? Because we seem sometimes it's like some of us are not prepared. Can we be told to what is going to happen next towards the finality of this?
Thank you, Honorable Tseki. As we have indicated, this is a draft A list, and there are still some few issues that need to be finalized, and then we'll then adopt the A list and then proceed to the B list, which is the final stages of the deliberations by the committee. Maybe let me give the legal person from the Parliament to add if I've missed something.
Thank you, Chairperson. Chairperson, just to go back before I deal with the process going forward, I just want to confirm that you are correct. We did deal with the issue of the frequency of board meetings. So we've dealt with that question that the Honourable Dr. Khumalo had raised, unless I've misunderstood what the Honourable Doctor has asked. But insofar as my understanding goes, we did deal with that in the A list. The second thing is regarding the way forward. You're 100% correct. What will happen now is we will go back with this draft and then with the additional questions and concerns, and we'll try and formulate and redraft the A list. And at the next meeting, we will go through the changes, and then it will be adopted, and then it becomes the B bill. Thank you, Chairperson.
Thank you very much.
Hello, Chairperson.
Yes, Honorable Koliswa.
Chairperson, I just want to also indicate that we were supposed to have this A list adopted today, but because there are some issues that still need to be ironed out, meaning that on Friday, we'll have to go back again to this A list as a draft. So if by Friday we manage to agree on the draft A list, it will be then adopted. Then which means we will have to have another meeting that will have to look at the A list as was adopted and the B version. So which means by Friday, we will be looking at this version again of a draft A list, taking into account what was discussed today, so that by the next meeting, which will be on a Wednesday, or any day that we will be able to meet to consider the B version of the bill. Thank you, Chairperson. And the report on the bill as well. Thank you, Chair.
Thank you very much, Koliswa. I think we agree, we're saying the same thing. Members have to adopt the A list before we can go into the B list. On Friday, our legal teams would be ready with those issues that are still outstanding?
Chairperson, we will work together as a team and be ready for you on Friday. Thank you.
Okay, all right. Thank you very much. Honorable Powell and Honorable Zeki, I see the hands is still up.
Thanks, Chair. I just want to confirm, I understand this is an exceptionally tight deadline for the legal advisors to work with. But can you please confirm that as MPs, we will be sent the A list the night before the meeting on Friday so that we can go through it in time to make sure that our submissions and the consensus that was achieved by the committee today on the exclusion of certain sections has indeed been reflected on the A list. My question really is whether or not the legal services team have got the turnaround time to revise the A list in line with quite a number of extensive recommendations today. Thanks, Chair.
Thank you, Honorable Powell. And as I heard them to say that they are going to meet and make sure that on Friday we have the A list, I think what your request is that they must send the list on Friday. On Thursday evening. Yes, on Thursday night, and then on Friday, then we deliberate on the A list, and then we are done. And from our side, me and colleagues would make sure that we get if this overlaps to other programs in other items in the program, we'll then see how we can then be able to prioritize this matter of the bill, because before we rise, we should actually submit our report to Parliament. We work to make sure that indeed we met our target, so that next year we are able to deal with other matters that is outstanding in the committee. Can you agree on that, members? I think silence means that we agree. Thank you very much. The meeting is closed, and we want to thank the legal team for taking us through this process. I know it's tiring, and your commitment has helped us to reach where we are today. Thank you very much. The meeting is adjourned, members.
Thanks, Chair.
Bye.